All right, so recording has started. Thank you all for joining us today in this workshop that we planned under Task T2.3. We have a very interesting series of presentations today. First of all, I am joined by my dear colleagues, Georgia Tsipras, Stavros Tsipras, Kostas Drakonakis, and Gregoris Chrysos. We all together work to make the presentations. We will going to have a very interesting presentation regarding the AI Act from Georgia and Stavros. Afterwards, I will take the token to present some useful insights from the preliminary analysis report that we conducted under Task 2.3. And we will conclude this workshop with an open discussion based on the final legal and ethics requirements that have been included as are the outcome of the task and have been included in deliverable 2.1. And Grigoris will be the chair of this open discussion. So again, thank you all for being here. Let's don't waste any more time. Just a kind request, in case you're not speaking, please keep your mics muted to avoid any interference and have the presentations run smoothly. So, Georgia, the floor is yours. You can start your presentation.
Just give me one moment. Okay, can you see my PowerPoint?
Yes, yes, we see.
Yes,
Okay, hello to everyone. I'm Georgia Tsipra. I'm a legal advisor with the AEGIS research team. And with this brief presentation, my colleague, Mr. Tsipras, and I will try to highlight the most important issues regarding the AI Act and the obligation it imposes on the placing in the market, putting into service or use of AI systems. It is important to highlight that the choice of a regulation as a legal instrument to regulate AI is justified by the need for a uniform application of the new rules. The regulation has a direct applicability on all the 27 members of the EU, with no need to incorporate it in their national legislative framework. Hence, the AI Act will reduce legal fragmentation and facilitate the development of a single market for lawful, safe, and trustworthy AI systems. So the preparatory work started 6 years ago, in 2018, with the setting up of a high-level expert group on AI, consisting of 52 experts, tasked to advise the Commission on the implementation of the Commission's strategy on AI. The white paper for the AI Act followed 2 years later to outline the key policy options and strategies for fostering the development and deployment of AI, balancing the need for innovation with the necessity of ensuring public trust in these technologies. AI Act supports the objective of the EU being a leader in the development of secure, trustworthy, and ethical artificial intelligence, and ensures the protection of ethical principles. The AI Act is the first ever comprehensive legal framework on AI worldwide. The aim of the new rules is to foster trustworthy AI in Europe and beyond by ensuring that AI systems respect fundamental rights, safety, and ethical principles, and by addressing risks of very powerful and impactful AI models. In this context, the AI Act is intended to advance 4 key objectives according to the explanatory memorandum of the Act. These are enhanced governance and effective enforcement of existing laws on fundamental rights and safety requirements applicable to AI systems. Ensure the AI systems placed on the union market and used are safe and respect existing laws on fundamental rights and union values. Ensure legal certainty to facilitate investment and innovation in AI. And last but not least, facilitate the development of a single market for lawful, safe, and trustworthy AI application and prevent market fragmentation. It is important to clarify some concepts that are constantly encountered in the regulation in order to better understand its content. The regulation itself, in Article 3, provides a number of definitions in order to make their use clear and harmonized. For the purpose of this regulation, the following definitions apply. Artificial intelligence systems mean software that is developed with one or more of the techniques and approaches listed in Annex 1 that follows the Act, and can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions influencing the environments they interact with. The AI Act emphasizes that a key characteristic that differentiates AI systems from simpler and more traditional software systems is their capability to infer. Provider, a natural or legal person, public authority, agency, or other body that develops an AI system or that has an AI system developed with a view to placing it on the market or putting it into service under its own name or trademark, whether for payment or free of charge. User, a natural or legal person, public authority, agency, or other body using an AI system under its authority, except where the AI system is used in the course of a personal, non-professional activity. Deployer, a natural or legal person, public authority, agency, or other body using an AI system under its authority. Distributor, a natural or a legal person in the supply chain, not being the provider or importer, who makes an AI system available in the EU market. Importer, a natural or legal person, again, located or established in the EU that places on the market an AI system that bears the name or trademark of a natural or legal established outside the EU, or legal person, established outside the EU. So now that we see the main definitions of the AI Act, let's follow to the next slide. The AI Act is broad in scope and comes with significant obligations along the value chain. It focuses on the impact of AI systems on people, specifically on their well-being and fundamental rights. It contains extraterritorial measures affecting any business or organization that offers an AI system impacting people within the EU, regardless of where the organization is headquartered. So in this sense, the AI systems impacts people living in the EU, whether are developed or operated within the EU or from elsewhere. The Act imposes different obligations across all actors in the value chain, as we already said. So providers placing on the market or putting into service AI systems in the Union, irrespective of whether those providers are established in the Union or in a third country, must comply. Also, it applies to users of AI systems located within the Union. Providers and users of AI systems located in a third country where the output produced by the system is used in the Union, and importers and distributors placing AI systems on the EU market. Now, on the other hand, the AI Act does not apply to AI systems used for purposes outside the scope of the EU lawmaking authority, such as military purposes. It does not also apply to public authorities in non-EU countries, nor to international organizations that have law enforcement and judicial cooperation agreements with the Union or with one or more member states, provided, of course, that there are adequate safeguards in place. Last but not least, again, this regulation is meant to help supporting research and innovation and should not undermine research and development activity and respect freedom of scientific research. Therefore, AI Act excludes from its scope AI systems specifically developed for the sole purpose of scientific research and development. Under all circumstances, any research and development activity should be carried out in accordance, of course, with the Charter of Fundamental Rights, Union law, as well as the national law. And this is without prejudice to the obligation to comply with this regulation when an AI system falling into the scope of this regulation is placed on the market or put into service as a result of such research and development activity. So let's now see all together the timeframe for implementation of this new act. EU Act was approved on March 13, 2024. It is expected to enter into force in the second or third quarter of 2024. The AI Act will become effective 20 days after its publication in the official journal of the EU. With regard to the most parts of the regulation, EU AI Act becomes applicable after 24 months. Of course, there are shorter deadlines, like in 6 months, that will apply for prohibited AI, and longer deadlines, like 36 months, for AI systems which are already regulated by EU law because they fall under the definition of a regulated product, such as medical devices, industrial machinery, cars, toys, etc., or AI systems used as safety component of a regulated product or regulated equipment. The penalties will also start after the 12th month of the Act's entry. The AI Act relies on a risk-based approach, which means that different requirements apply in accordance with the level of risk that arise from the application for which AI systems are used. AI systems are classified as follows in the Act. Unacceptable risk. These are uses of AI Act that create an unacceptable risk, and they are prohibited. Title II of the AI Act provides a list of prohibited practices of those AI systems whose use is considered unacceptable as contravening union values, for instance, by violating fundamental rights. High risk. AI systems that are identified as high risk to the health and safety of fundamental rights of natural persons have to comply with strict requirements and an ex-ante conformity assessment. Title III of the AI Act contains specific rules for these AI systems that create high risk, and they are permitted as long as these requirements are met. Then we have limited risk category. It refers to the risks associated with lack of transparency in AI usage. The AI Act introduces specific transparency obligations to ensure that humans are informed when necessary, fostering trust with that. And last, there are minimal risk. There are no restrictions to minimal risk AI systems. The AI Act allows free use of these AI systems. So now we'll try to identify these 4 different levels of risk for AI systems and the requirements for compliance with the Act, when necessary, of course, according to their classification. Title II of the AI Act establishes a list of prohibited AI systems. This list of prohibited practices comprises all those AI systems whose use is considered unacceptable as contravening union values and fundamental rights, and their placing on the market, putting into service, or use is strictly prohibited. In this and in the following slide, we see the AI systems which are prohibited according to the AI Act, with some exceptions that apply in specific cases, since there isn't a law without exceptions, as you may already know. Under this category of prohibited AI systems, there are cases such as systems that deploy subliminal, manipulative, or deceptive techniques to distort persons' behavior, systems that exploit any of the vulnerabilities of persons due to their age, disability, social or economical situation to distort their behavior again, biometric categorization systems that categorize individually natural persons based on their biometric data to deduce or infer their race, religious, and any sensitive data. AI-based social scoring, such as evaluating or classifying individuals or groups based on social behavior or personal characteristics, which could lead to detrimental or unfavorable treatment of those people. use of real-time remote biometric identification systems in publicly accessible spaces for law enforcement. You can see the exceptions that apply here. The exceptions, of course, there are in cases like targeted search of specific victims of abduction, trafficking in human beings, and sexual exploitation of human beings, as well as search for missing persons. However, also in these exceptions, before deployment, police must complete fundamental rights impact assessment and register the system in the EU database. So there are also systems making risk assessments for natural expansion in order to assess or predict the risk for these persons to commit a criminal offense based solely on the profiling of a natural person or on assessing their personality characteristics, which are also prohibited. AI systems that create or expand facial recognition databases through the untargeted scrapping of facial images from the internet or CCTV footage, and systems of AI that infer emotions of a natural person in the areas of workplace and education institutions. We pass now to the third category, limited risk systems, since the second category of high-risk systems, which have significant compliance requirements, will be elaborated by my colleague after me. This category refers to the risk associated with lack of transparency in AI usage. The AI Act introduces specific transparency obligations to ensure that humans are informed when necessary, and by this, fostering trust. For instance, when using AI systems such as chatbots, humans should be made aware that they are interacting with a machine so they can take an informed decision to continue or step back if they want. Providers would also have to ensure that AI-generated content is identifiable. AI-generated text published with the purpose to inform the public on matters of public interest must be labeled as artificially generated. And this also applies to audio and video content constituting deepfakes. Deployers must inform and obtain the consent of people exposed to permitted emotion recognition or biometric categorization systems, such as AI safety systems that monitor drivers' attentiveness. As we saw, AI systems are categorized into different levels of risk based on their potential impact on society and the level of harm they could cause. The systems categorized as limited risk are considered less risky than the high-risk ones. And now we have AI systems that do not fall into the above categories, are considered of minimal or no risk, and they have no obligation under the regulation. Some examples of such applications include AI-powered video games and spam filters, photo editing software. The key aspect of the regulation is to minimize regulatory burdens placed on such systems, thereby promoting innovation and development in areas where risks associated with the use of AI are deemed negligible or non-existent. By doing so, the Act aims to create an environment conducive to the growth of AI-driven technologies, which in turn can benefit a wide range of industries and users. The Act, however, invites stakeholders to commit to codes of conduct on a voluntary basis on users of minimal risk systems. So I will now give the floor to my colleague, Mr. Tsipras. He's also a lawyer, to elaborate on the issues and obligations raised by the regulation regarding high-risk AI systems, and to conclude this brief presentation on AI Act. Thank you all for your attention and your patience. Thank you.
Thank you, Georgia. Before we move on with the Stavros presentations, I saw we had a question from Sariful. If you want to make your question now or wait for Stavros to conclude his presentation.
Okay, I think let me ask the question, otherwise I may forget it. So Georgia, thank you for the presentation. So my question is, you see there are, you have presented that there are 4 different compliance level, right? So that means that for my understanding, I mean that if I developed a AI product, AI-enabled solutions, then the solution need to go through a audit, right? To make a ranking that what compliance level my product can be achieved. Am I correct?
You are correct. The first thing that you have to do is try to find out in which category falls your product. You see that you have to understand if it is a product, a system that it is of. If it is forbidden, you forget it. Okay. You do it at your place, nobody has to know about it.
Okay.
If it is a product that may pose high risk, you definitely have to be in conformity with the regulation and be in compliance with it. Stavros will explain us which is the things that you have to do to be in compliance with the law. If it is in minimal risk, you don't have to do anything with the law. So first thing you do is you take your system and you try yourself to categorize it, to see in which category it falls. And then if you need to take any steps to be in compliance with the law, you follow the steps under the category that you are.
Okay, so that means that in that case we need to do a self-assessment, right, of the product.
Exactly, definitely.
But do you have any guideline for that from the AI Act, or is there any checklist exist for that?
Well, they said that they will prepare sandboxes. I'm not aware if you are familiar with the term. Every member state will develop with the competent authorities that they will address. They will develop some sandboxes. They call it sandboxes, so as everyone who wants, and especially companies, they can do a self-assessment first and to see in which level of risk they fall into.
All right. Okay.
There are instruments also for the European Union, but you see the law, it's still fresh. I mean, it's not still into force. It has not been, it has not started yet. We are all waiting to be published in the European Journal, official journal, and then to start see how it will be implemented, because it will need time to see the law in the action.
Okay. Okay. Thank you. Finally, are you going to sharing this slide with us?
Sorry?
Yes, Ariful.
Yeah.
We will share the presentations, and we are recording the session, so everything will be uploaded on the SharePoint of CyberSecDome. All the information will be available. Thank you. Thank you for your question. Okay, so now we can move on with Stavros' presentation, which is actually the continuation of George's presentation, focusing on the mid category, if I'm not mistaken, right? So Stavros, the floor is yours. You can share your screen whenever you want.
Just give me a minute, because I have the same issues I had earlier with the presentation. It doesn't show.
Okay.
Okay.
Are you okay?
No, it's okay.
Okay.
I managed. Okay, you can see the presentation.
Yes, we see the full presentation. Thank you.
Okay, thank you very much. So about high-risk systems, these are based in use cases. There is an Annex 3 where they are categorized there, and you can go there and see what has happened so far and see if your system is a high risk. So, so far, high-risk systems that are subject to conformity assessment and obligation are AI system that used as a safety component or a product covered by the European Union's harmonization legislation, such as medical devices, marine equipment, motor vehicles, agricultural vehicles, machinery, civil aviation, or toys. And AI systems that applied in uses that pose a significant risk or harm to health, safety, or fundamental rights, such as biometric identification and categorization of people, management and operation of critical infrastructure, education and vocational training, employment, worker management, and access to self-employment, access to and enjoyment of essential private and public services and benefits, Law enforcement uses such as data analytics systems to assess evidence of criminal activity, migration, asylum, and border control management, and administration of justice and democratic processes. This, as I said, is use case based. It's not a definition of what is a high risk system. Okay. There are some exceptions to high risk classifications, such as the AI system is not considered a high risk if it performs a narrow procedural task with no direct safety or security implications, or if it is meant to review or improve the quality of human output, or is used to detect decision-making patterns but without influencing the decisions. And finally, if it's used for purposes of detecting financial fraud. These are not high-risk AI systems. So now we go to see the obligations for providers. There are some general obligations, such as the providers should establish and maintain appropriate AI risk and quality management systems. They should have effective data governance, maintain appropriate technical documentation and record keeping, transparency and provision of information to users. This also applies to other tiers of AI system. Transparency is a must for everything. Enable and conduct human oversight, compliance with standards for accuracy, robustness, and cybersecurity for the intended person, and register the high-risk AI system on the European Union's database before placing them on the market. System used for law enforcement, immigration, asylum, and border control and critical infrastructure will be registered in a non-public section of the database. The obligation for pre-market conformity assessment for high-risk systems. So the providers must perform a conformity assessment of the high-risk AI system before placing it on the market. The conformity assessment should examine whether requirements laid above have been met. And in most cases, the providers, we can self-assess if we apply procedures and methodologies that follow European Union's approved technical standards that allow a presumption of conformity. There are some cases that the third-party conformity assessment by an accredited body is required if the AI system is part of a safety component subject to third-party assessment under Union harmonized rules. The AI system is part of a biometric identification system, or if harmonized standards are not used at all. The post-market obligation of the providers, there are still obligations post-market. We have to maintain logs generated by high-risk systems to the extent that they are under control for a period of at least 6 months. Immediately take the necessary corrective actions for non-conforming systems already on the market and inform other operators in the value chain of the non-conforming systems. Cooperate, of course, with the national competent authorities of the AI office. Monitor the performance and safety of the AI systems throughout their lifetime and actively evaluating the compliance. Report to the appropriate authorities serious incidents and malfunctions that lead to breaches of fundamental rights. And this is important, undergoing new conformity assessment for substantial modifications. So there are some changes to a system intended personal changes that affect how it meets regulations, whether the changes are made by the provider or by any third party. For AI systems that are considered to have limited or minimal risk, it will be important to check whether the original risk classification still applies after the changes. Okay, the obligation of deployers, importers, and distributors. They have to complete a fundamental rights impact assessment before putting the AI system in use. If the deployer is a public body or private entity providing public services, or if it provides essential private service that cover creditworthiness, evaluation of person, and risk assessment and pricing in relation to life and health insurance. They should implement a human oversight by people with the appropriate training, ensure that the input data is relevant to the use of the system, suspend the use of the system if it poses a risk at a national level, inform the AI system provider of any serious incidents, retain the automatically generated system logs, comply with the relevant registration requirements when the user is a public authority, and comply with the GDPR obligations to perform a data protection impact assessment, and verify the AI system is compliant with the AI Act and that all relevant documentation is evidence, and inform people that they might be subject to the use of high-risk AI. The general purpose AI is also regulated in the AI Act. The example, virtual personal assistants, autonomous vehicles, and language translation, sorry. There is also a tier here about the GPAI models. There's a base level tier, which includes everything. There is a limited transparency obligations here. And there is the systemic risk tier, where high-impact GPAI models pose a systemic risk and provisionally identified based on cumulative amount of computing power used for training. A model can also be classified in this tier based on a decision of the Commission that the general-purpose AI model has capabilities of impact equivalent to those above. There are significant obligations for compliance for this kind of GPAI systems. So, in general, the providers of all GPAI models will be required to keep and maintain up-to-date technical documentation, make information available to downstream providers who intend to integrate the GPAI model into their AI systems, put in place a policy to respect the European Union's copyright law, and disseminate detailed summaries about the content used for training. There are some exceptions here. Unless the GPAI models present systemic risk, these obligations shall not apply to providers for GPAI models that are made accessible to the public under a free and open source license, and whose parameters are made publicly available. If there is a high-impact GPAI model that poses systemic risk, the providers must perform model evaluation, assess and mitigate systemic risks, document and report to the European Commission any serious incidents and the corrective action taken, conduct adversarial training of the model, ensure that an adequate level of both cybersecurity and physical protections are in place, and document and report the estimated energy consumption of the model. So, in the end, the regulatory oversight will look like this. Each member state will have a national competent authority, which will be given oversight powers. And at the EU level, the AI Act will be, there will be an AI office with functional independence from the European Union Commission, which will have oversight responsibility for GPAI models, and it will contribute to the development of standards and testing practices, coordinate with the national competent authorities, and help enforce the rules in member states. An AI board representing the member states to provide strategic oversight for the AI office, which will support the implementation of the AI Act and regulations, including the design of codes of practice for GPAI models. A scientific panel of independent experts to support the activities of the AI office, which will contribute to the development of methodologies for evaluation of the capabilities of GPAI models and their subsequent classification, while also monitoring possible safety risks. And an advisory forum with representatives of industry and civil society, which will provide technical expertise to the AI board. So now the penalties. You see, there are different penalties for different level of non-compliance. So if you breach the AI Act prohibitions, the fines are up to 35 million on 7% of total worldwide annual turnover, whichever is higher. You see, you can't put something to the market that is prohibited if you have the money to do so. Non-compliance with the obligations set out for providers of high-risk AI systems or GPAI models, authorized representatives, importers, distributors, users, or notified bodies, fines up to 50 million or 3% of total worldwide annual turnover. And if you supply incorrect or misleading information to the notified bodies or national competent authorities in reply to a request, the fines are up to 7.5 million or 1.5% of total worldwide annual turnover. But in case of small and medium enterprises, the fines will be as described above, but whichever amount is lower. Sorry. National competent authorities will determine the fines in line with the guidance above. So, as SMEs, what action should we take from the outset? We should inventory all the AI systems we have developed or deployed and determine whether any of these systems falls into the scope of the AI Act. Assess and categorize the in-scope AI systems to determine the risk classification and identify the applicable compliance requirements. Understand your organization's position in relevant AI value chains, the associated compliance obligation, and how this obligation will be met. Compliance will need to embed it in all functions responsible for the AI systems along the value chain throughout their life cycle. Consider what other questions, risks, opportunities the AI Act poses to your organization's operations and strategy, and develop and execute a plan to ensure that the appropriate accountability and governance frameworks, risk management and control system, quality management, monitoring, and documentation are in place when the Act comes into force. So this concludes this presentation. And if there are any questions, we'll be happy to answer, or try to anyway.
Thank you, Stavros, for the presentation. I don't know if there are any comments or questions regarding the presentation Stavros made.
No comments from my side, just another video presentation with much information. It was much needed.
Sorry, Anna Maria, we didn't hear you. Well, at least me, there was a lot of noise. Sorry for this. Could you repeat, please?
Yes, sure. Sorry, I was just saying that the information was really good, with a lot of information. It were much needed. So thank you, Stavros.
Thank you for the comment, Anna Maria. By the way, if you find this presentation of AI Act very interesting, we're discussing internally in AEGIS a similar presentation that would be done for the Cyber Resilience Act. Stavros and Georgia have been studying both AI Act and Cyber Resilience Act for quite some time now. So perhaps maybe at the plenary in Paris, we could have a presentation there for the Cyber Resilience Act, which is also very important for CyberSecDome. That's just an idea from our side. So if you'd like to see something like that there, please let us know, and we will handle that. We can make that presentation, I guess, over there. So thank you again, Stavros. Let's move on with the next presentation. Actually, I am going to share my screen now to present, let's say, the insights from Task 2.3. I think you can see my screen. Please let me know.
Yes, Spiro.
Thank you. So this presentation, as I said, is going to focus on the work we have been doing under Task 2.3 with some insightful information about key legal, privacy, and ethical requirements that we found, and also apart from the overview of the task, I will also provide some overview for the methodology that we followed, some key findings, as I said, both from the analysis from the literature and the questionnaires, some high level recommendations that we also documented in the report, and some suggestive next steps that CyberSecDome follow based on this preliminary analysis. So first of all, the task was a collaborative effort that was led by us, AEGIS, with the support of TUC. We started back on month 1 of the project, and April is our concluding month 8. So during this whole period, we focused on examining the legal regulatory and ethical frameworks at both national and European levels that could impact the work. As I said, the aim is to ensure that the CyberSecDome architecture aligns with data protection, security standards, and ethical norms, setting a robust foundation for the project's development phase. The methodology, the approach that we had during the analysis was multifaceted because we started with an extensive literature review to better understand the existing legal framework, like the GDPR or the NIS Directive. We also engaged with experts from legal cybersecurity and AI ethics fields and gathered, of course, information and insights from the questionnaires that we shared with you all. But all of that helped us to identify compliance challenges, but also best practices that could be followed. Our analysis, though, did not stop in existing legislation. As you saw, we also looked forward, assessing the potential impact of upcoming regulations, such as the AI Act and the Cyber Resilience Act. And this proactive approach will ensure that CyberSecDome not only meets current standards that are in place, but also be able to adapt to future changes. Here are some key findings from the literature that are actually documented in detail under sections 3, 4, and 5 in the preliminary analysis report. We have included them in deliverable 2.1. So first of all, regarding the data protection and privacy, to comply with the GDPR regulations and build trust with users, it is important, as we all know, to focus on minimizing the amount of data collected and processed. The principle is to only gather and process necessary information, which helps to lower the risk that is associated with storing and handling data. But we also need to ensure uniform security across all partners in the CyberSecDome. This has been identified as a challenge because of the diverse technologies that the partners bring and the processes they bring into the project. So to achieve this, all partners will need to adhere, let's say, to a common set of security protocols and practices for the CyberSecDome progression. Of course, for the data privacy and protection, data encryption and retention are critical areas that also need immediate action. And the report emphasizes deploying state-of-the-art encryption technologies to protect data, both at rest and in transit, and establish clear data retention policies that comply with legal requirements and best practices. Now, for the cybersecurity and adherence to cybersecurity guidelines and directives, particularly the NIS Directive, it's crucial for maintaining data storage and processing integrity and security. And the project's commitment to following these guidelines will ensure that we have a robust defense against cyber threats. The report highlights the fact that CyberSecDome has a proactive approach to cybersecurity with ongoing efforts to align with state-of-the-art standards and practices, as we said. And this includes regular security audits, penetration testings, and the implementation of advanced threat detection systems to safeguard data exchange across the network. Finally, for the ethics, the ethical deployment of AI technologies also became a focal point within the report, which stressed out the importance of designing, let's say, AI technologies that ensure fairness, transparency, and accountability. This, of course, involves technical measures to avoid biases in AI algorithms and ethical guidelines to govern the use of AI within the project. So to this direction, continuous monitoring, of course, of ethical standards is essential for maintaining the ethical integrity of these AI technologies. Moving on, I would like to demonstrate here a glance, a screenshot from the questionnaire that was circulated to all the partners that provided useful insights for the report. The questionnaire was available in printable format in Word doc and also online on online format. Drawn from the detailed questionnaire, for example, in the first direction that we followed, data privacy and protection, this chart here shows CyberSecDome partners uphold how they uphold data privacy and protection. Highlight is that 80% of the participants, as you see that the diagram, refers to the GDPR compliance measures, and this reflects strong consensus on the importance of strict adherence to data protection laws. Additionally, 75% of the partners mention the adoption of flexible data architecture, which speaks to the adaptability, let's say, in managing various data types. And these figures here collectively underscore the dedication to robust data privacy practices and the dynamic nature of the cybersecurity strategies that can be implemented and will be implemented eventually in CyberSecDome. Moving on with the next pivotal aspect of the analysis, the cybersecurity regulations. This chart here reveals, let's say, the collective stance of cybersecurity, of CyberSecDome on cybersecurity regulations. Notably, as you see here, 85% of our partners prioritize regular security updates and policy revisions, demonstrating by this way a robust, let's say, commitment to cybersecurity resilience. In addition to that, 80% underscore the importance of cybersecurity monitoring and reporting, which is a key component in the overall, let's say, security infrastructure of CyberSecDome. So these figures highlight the areas where the partners excel in regarding the cybersecurity and the cyber resilience, but also the plethora of the approaches from partners, which, by the way, brings, let's say, a challenge into the project of shaping a unified approach to strengthening CyberSecDome's cyber defenses as a framework. I mean, finally, this graph here outlines some key findings from the questionnaire in the area of ethics and AI, showing that an overwhelming 85% of the participants prioritize the need for explainable AI and human oversight. This highlights the commitment of CyberSecDome to ethical transparency and the critical role of human judgment in AI systems and technologies. Moreover, 80% of the participants advocate for transparency and bias mitigation, reinforcing the importance of ethical considerations in AI development. These findings here emphasize the collective dedication from the CyberSecDome partners to developing AI technologies that are not only, let's say, advanced, but also ethically sound and accountable. Some key findings from the questionnaire, as we already said, to perform the task and have the preliminary analysis report, we circulated questionnaires among the CyberSecDome consortium partners, and the analysis from these questionnaires revealed some insightful information. Again, in the three pillars of the data protection and privacy, the cybersecurity, and the ethics. So, for data protection and privacy, of course, the consortium fully commits to GDPR, as we know, compliance and alignment with Directive 2016/680. The responses from the questionnaire highlight the significance of implementing strict data minimization practices to reduce the possibility of data breaches. Encryption is also critical to maintain the confidentiality and integrity of data during transit and storage, as we said. And in order to comply with the regulations and empower users, it is necessary, as the partner pointed out in the questionnaire, to improve data portability and encryption capabilities. This will give users greater control over their data and promote trust and transparency. We always speak about personal data, but not restricted to personal data. Now, adhering to the state-of-the-art of cybersecurity standards, as we said earlier, this is paramount, and it was well evident throughout the questionnaire by all partners. The NIS Directive is the critical, let's say, benchmark for establishing robust data processing and exchange mechanisms. And the consortium's responses demonstrated what we already said, a proactive approach to cybersecurity by incorporating guidelines and directives to establish secure networks, network architectures, let's say, and data exchange protocol. And this proactive approach is vital in addressing the dynamic nature of cyber threats, as we said already. Finally, for the ethical considerations, especially considering AI, um, these considerations emerged as, let's say, a central theme of the questionnaire. So, upholding data transparency, accountability, and fairness is paramount, not just as a legal obligation, but as a moral imperative as well. That was highlighted from the questionnaire. There is a collective acknowledgement, let's say, from all the partners regarding the risk of disseminating, for example, fake information. And this underscores the importance of ethical AI models to safeguard against bias and misinformation and ensure the data integrity. The consortium's feedback basically aligns, let's say, with the broader objective of establishing ethical standards that meet current expectations and anticipate future ethical dilemmas in AI application. Let's say, to conclude, the responses from the consortium members in the questionnaires, as analyzed extensively in section 10 of the report, emphasize a unified vision, let's say, towards achieving exemplary standards in privacy, cybersecurity, and AI ethics. The diverse approaches of partners in handling data, cybersecurity practices, and ethical AI considerations particularly highlight the importance of having collaborative efforts in, let's say, standardizing somehow practices and frameworks towards this direction. So this diversity, while it is a challenge, it also presents, let's say, an opportunity for sharing best practices and innovations. I mean, internally, knowledge sharing among partners. The goal eventually is to align with the existing regulations, of course, ethical standards, and lead the way in maybe perhaps even define new benchmarks for digital security, privacy, and why not ethical AI. So in summary, the CyberSecDome consortium is committed, let's say, to setting exemplary standards in all of these directions. And to achieve this, the consortium should encourage, let's say, collaborative efforts and share the best practices among partners. So this was one of the key findings. So some high level recommendations that were the result, let's say the initial result of this preliminary analysis are enlisted here. So the most important, as you can see, recommendation is to ensure that all data processing activities comply strictly with the requirements of the GDPR. This is especially critical when dealing with special categories of data, which require, let's say, heightened safeguards and explicit consent mechanisms. To achieve this compliance, it is essential, we need to say that, to implement rigorous data protection impact assessments, the well-known TPIA. So this is a strong suggestion, might say, and transparent data processing protocols. It is also important to establish systems and procedures that enhance the right of data subjects, such as the data portability, as we said, and also the right to erasure. So for the data subject to have the right for its data to be deleted. So these steps foster a transparent and trust-based relationship with the end user. Regarding now the cybersecurity standards and guidelines, as we said, adhering to state-of-the-art cybersecurity standards and guidelines, including NIS Directive, is a must, not just a recommendation. This involves, of course, incorporating advanced cybersecurity protocols across all CyberSecDome components, and ensuring a unified and robust defense mechanism against the cyber threats, and of course, regular cybersecurity assessments, vulnerability scans, adherence to international standards, and recommended uh, and recommendations are, let's say, suggested here to maintain and enhance the CyberSecDome's security posture and ensure that it remains resilient against evolving threats, cyber threats. Finally, the recommendations here highlight the importance of, let's say, ensuring, as I said, fairness, transparency, and accountability in data usage for the AI-based systems. These involves developing and implementing ethical guidelines that govern the AI use, including bias detection and mitigation mechanisms to ensure AI systems operate without prejudice. And adopting frameworks such as the OpenAir e-evidence, it is advised to enhance compliance and cybersecurity measures. So, because these frameworks actually facilitate a real-time monitoring and evidence collection, enabling, let's say, proactive response to legal and security challenges. So, moving on now, uh, here is a series, let's say, of next steps on how these high-level recommendations we talked about could be, for example, implemented, or what CyberSecDome could do or should do past the preliminary analysis findings. So, starting first of all and foremost, CyberSecDome must implement the recommendations into operational, technical, and ethical framework. So it's not only just having a compliant framework, but we also need to apply the regulations in all of our processes. So these recommendations include enhancing data protection policies, upgrading cybersecurity measures, and ensuring the ethical design and operation of AI technologies. However, requires a collaborative effort across all project aspects to ensure, let's say, seamless integration. Also, review sessions, having regular follow-up sessions could be held uh, you know, we have these to monitor the effectiveness, the implementation progress, compliance status with the GDPR and the NIS directives, and of course, the ethical deployment of AI technologies. These reviews will also encourage, let's say, the continuous learning and adaptation to respond dynamically to new challenges and new regulations. Also, internal, let's say, reviews, encouraging that is also important for adherence to recommendations, because these reviews will help, let's say, assess the compliance, identify gaps, and make necessary adjustments. Also, this approach, having internal reviews by partners within their organizations, I mean, will promote, let's say, the shared responsibility and the continuous improvement among continuous consortium members. Finally, having, let's say, collaborative efforts and continuous improvements, we need to make sure that the project, the consortium, will commit to ongoing evaluation and adaptation in compliance and ethics. The project needs to stay updated with legal and cybersecurity advancements, and of course, all the ethical discussions that have to do with AI. So, by engaging, for example, with experts, the consortium can aim to set responsible digital infrastructure development standards. So all of these suggestive next steps could represent, let's say, a roadmap for CyberSecDome to, let's say, solidify its legal compliance, cybersecurity and ethical responsibility foundations. And by following through these actions, CyberSecDome will be able to achieve its project goals and contribute, let's say, why not, to the broader discussion and practices in the digital ethics and security. And practically, this ends my presentation. Thank you. Thank you for your attention. I don't know if you have any questions. Please let me know. Yes, I see. Yes, Arif, please.
Hi, okay, so one quick question I want to share my experience is that my team is now working, developing, we are developing a software vulnerability detection by using AI model. Okay, so we have already developed the model and do the experiment in our side in ARU. On top of that, we are trying to implement the responsible AI properties. Okay, for example, the fairness, security, reliability, transparency of the model we have generated. Okay, so now when I try to do that, it is we are really struggling. Like you develop a model, you develop an outcome of the model, which is very fine. Everybody can do it. But when you try to implement some experiment regarding checking the techniques relating to fairness, or regarding checking the techniques, like for example, advisable attacks or data poisoning attack for security, it is really not an easy job. Okay, but we succeed somehow with achieving all the assurance of responsible AI property. So my recommendation is, like in our project, there will be after 2 years later there will be multiple AI-based solutions produced, right? Now, if we want to achieve your third bullet point, like ethical AI, then pen and paper you can say yes, we achieve all the things. But if you really want to achieve it, then somehow we need to follow doing when you develop the model, we need to see that how the experiment can be done to do applied some of the techniques for fairness or some of the techniques for data poisoning or reliability to check that the model is fair, transparent, and reliable. Okay, so I would say that from your side, you should say that when you develop some model should be complying, and there should be some level of assurance of confirming that the responsible AI or ethical AI achieves. So that's my recommendation, so that you could, at the end of the day, you say that you want to achieve the more legal based foundation. So that could be one way to move on. Thank you.
Thank you, Sharif, for the comment. It also provides a good opportunity to say that what I just presented was, let's say, the high level aspect of recommendations, because the actual, let's say, recommendations that we came up from the preliminary analysis will be presented in the open discussion now. These are the ones that were also documented in deliverable 2.1, the table from the deliverable that have to do with the recommendations. But I totally agree with you that it is not as easy as it is written in the slides, for sure. But what was impressive through the questionnaires was the fact that there is, that's why I highlighted a lot of times, that there is a diversity among the partners on let's say, the know-how on all of these aspects. And this is also good and bad. Good from the point of view that we can exchange knowledge and move forward collectively. But also a challenge because it is tricky on how this is going to be implemented within the project. It's not an easy task. So I hope, and I am sure that the discussion that will follow up now will provide, let's say, will let some light and let us know how we can proceed in detail and in on a more technical, let's say, aspect of the discussion. Thank you for the comment. Thank
Maybe
you.
we can give some best practice guideline that for fairness you need to do these things, or for reliability we can give some guideline, and all our AI enabled solution develop that can follow it at least some level. Then you can confirm that it is achieved. Thank you.
Thank you. Thank you, Sharik. Any other questions or comments?
Maybe I have a couple of comments also to kind of help kickstart the discussion. Okay, first of all, based on Sharif's initial comment on if there is any method to, for self-assessment when you're developing an AI model, I'm not entirely sure, but maybe until the sandboxes that Georgia mentioned, which will be a more practical approach, maybe the corresponding partners can utilize the, remember the AI-related questionnaire from the European Commission? It was also embedded. It was also embedded in our questionnaire, but I'm not entirely sure which partners actually filled that. So in case someone didn't do it, maybe it would be a good starting point.
Yes, we had that in the questionnaire as a link, so it would be a good starting point to have a self-assessment on that. I think it was the questionnaire of filter. Stavros, please jump in if you want, because you are well aware of that.
Yes, there is the high-level ethics group or experts group on AI. They have created the questionnaire, which is an online document, the Altai questionnaire.
The Altai, yeah.
For self-assessment, you can create an account there and put the project name and start answering some questions. Other questions pop up as you go, depending on your previous answers. And it comes up with some numbers and some suggestions as well. It's very useful tool.
Yeah, that's great. Thanks.
At this stage.
And I see Kostas has shared the link again to the chat. So if you want to check out, everybody, and provide us with the results, that's very interesting, because we hoped we would have some results from that self-assessment, let's say, to include in the preliminary report.
I'm speaking.
Yes, yes, Georgia, please.
Okay, great. I just wanted to make a comment after Mr. Drakonakis' comment that it was very fruitful because, as I said earlier, and maybe it wasn't very clear, every member state will have, through the competent authorities that they will have, to provide with these sandboxes, which everyone, every corporation, every business will be able to use them and to see if they are compliant with AI Act or not, according to their system. But the things that we know now is that this sandbox has only been regulated in Spain. Spain was the first country that put it into force. So we will start to have feedback from these sandboxes, and I think that they will be very useful for businesses through Europe, that they will try to have guidance from the competency authorities that they have in their country. Spain will be the leader in that.
May I ask one question from my side? I'm not sure though if there is an answer yet on this. Why does each country need to have its member state a different sandbox, and can't they all have, let's say, a unified sandbox so that everyone, European SME or anyone could, let's say, test or and self-assess in that sandbox? So, for example, if the sandbox of Spain is already active, could I test it perhaps?
I think, Spiros, maybe this is that because they want to gather more data. So maybe in the meantime, finally, it will also be something regulated as a great sandbox, let's say, in the EU level. But maybe it's more easier to go to my competent authority and to know that I can have self-assessment there. So probably they will end up having one united sandbox, I think, maybe, I suppose, I don't know.
Thank you, Georgia. Any other comments or questions?
I have another suggestion actually.
Yeah.
Based on thanks, Georgia, for the comment. Really useful. Thanks. Based on Georgia's presentation, we see that there is a clear definition in the AI Act for what is considered an AI system, and it's defined something like any system that is developed with one or more techniques listed in the annex of the Act, right? So maybe a good starting point for the consortium, in its entirety, could possibly be to set an action point to, its partner that incorporates anything remotely connected to AI in their pipeline, in their components or whatever, to actually, as an initial first step, check out these requirements and see if they actually do fall under the AI Act. And I'm saying this because, in the context of the projects, we are referring to the entire security tools as AI-enabled tools. While in reality, some of these, if I'm not mistaken, for instance, the intrusion prediction system from STS. I don't know if we have someone from STS today. It is supposed to be listed under the AI-enabled tools, but essentially, it's a machine learning-based mainly tool. So it's not clear, at least to us, as outsiders, if the AI Act should be, also considers this specific component. So yes, my suggestion would be that each partner that incorporates something related to AI, or completely AI based, to actually check out this annex from the Act and figure out if it actually applies to them. Because if it doesn't, then they're clear.
Thank you, Costa. I think this is a good point. My guess is that this is part of the self-assessment process from the entire questionnaire that we ask the partner to, let's say, do and have a self-assessment there. But it wouldn't hurt if we have this. We will try to upload it. I think it was on Georgia's slide. We will try to upload this definition again and at least have the partners read it and try to self-evaluate whether their technology is under that that term, that definition.
Yes, definitely. And maybe we can, I don't know, set it as an action point for the upcoming plenary, the remote plenary, so we can just have a clear picture on which components are affected. So yeah, that's from my side. That's it from my side. Thank you.
Thank you, Costa. Let me stop sharing my presentation, and I think we can move on now with the final session of this workshop, which is actually the open discussion, which has already started. But I'm sure that Greg, you would take over and try to conduct an open discussion based on the findings of the requirements, of course, or anything else that we presented today. I think. So the floor is yours.
Okay, thank you. Actually, if there are no open issues that we need to discuss here, we want to present you the results and the outcomes of these questionnaires that the CyberSecDome participants filled out. So I will share my screen now. Okay, can you see my screen?
Yes.
Yes, good. Okay, this presentation is about the results of.
Sorry to interrupt you. Actually, I think we see at least me, I see the PowerPoint, not the presentation.
Yeah, you need to make a full present mode. It's not in a full
Yes.
presentation mode.
No, I changed it to slideshow. Now? No?
No, we still see PowerPoint up, but not the full presentation.
Sorry. Okay, now?
Now we see the slide. Yeah,
Great.
full presentation mode. Thank you.
It's full presentation. Okay. So this presentation is about the results of Task 2.3, and there are some directions that need to be clarified from the results, from the outcomes of this task. First, we tried to group the CyberSecDome legal and ethical directions that Spiros presented before. There are three specific directions. The first one is about data privacy and protection. And there we need to follow GDPR directions. We need to move on careful attention to data types and processing activities. And also, we need to follow national and data protection laws. The second direction for CyberSecDome is cybersecurity, which is really the main topic of this project. In this direction, we need to move on network information system directives, safeguarding network and information systems using continuous action monitoring and using the best practices for facing the issues. Last, the last direction is about ethics, including AI, of course. And there, it is really important the addressing of potential biases and ensuring user privacy with clear accounts and transparency. Now, the requirements based on the deliverable, the outcomes of this research, are grouped in the three groups. And the first group, which is about data privacy and protection requirements, consists of two main requirements. The first one is about data minimization and concept management. which is a functional-based requirement. It is obligatory. It should be applied to the CyberSecDome results, and it is based on 3 main tasks. Task 3.1, which is about data acquisition and preprocessing model training. Task 7.3, which is about communication and threat intelligence sharing. And tasks 5.1, which is about the alignment of the implemented tasks with pilots. There, for example, speaking about IDPS, intrusion detection prevention tool, we follow this direction based on the communication between intrusion detection and intrusion protection prevention tool, and also between the communication IDS and Airbus incident investigation. Here, I don't know if from the participants, if the participants have other information about, are there any data minimization mechanisms in their tools? Is someone who wants to comment on this direction? No. Okay, so I move on the second data privacy and protection requirement, which is about encryption and anonymization standards. These standards need to be applied to the final CyberSecDome framework. It is, again, functional category, and needs to be applied. There are, again, 3 tasks: intrusion detection and prediction framework, incident investigation, and cooperation among CyberSecDome frameworks from ITML. And for example, here, intrusion detection does not have any specific direction for applying encryption or anonymization standard, but I think that based on the description of work of the project, there are some frameworks that will apply them. So this is a specific requirement that needs to be used, and needs to be applied to the final system. The second group of requirements is about the cybersecurity compliance. And here we have 9 directions, 9 requirements. The first 4 are functional, and the rest are non-functional. The first 3 are presented here, and it's about secure coding and audit practices. We need to use static and dynamic code analysis and conduct periodic security audits. There are 2 tasks that focus on this direction. One is from Security Labs partner, and focus on dynamic risk analysis and the AI-based automatic frameworks. And the other one is dynamic incident response planning and adoption. The second cybersecurity compliance requirement is about threat modeling and vulnerability management. This part, the partner that is going to work on this direction is mainly Institute Mind Telecom, and who is responsible for both these 2 tasks, 7.4.1 and 4.2, and which is about collaborative virtual reality interfaces and AI frameworks for better understanding security operations. The third requirement, cybersecurity requirement, is incident response strategy. There, we need to define exactly what are the actions that tools need to move on when incidents, cybersecurity incidents take place. This, its main characteristic is that it is based on all the main running tasks of CyberSecDome implementation. And I have notes here about IDS, and I write that the IDS and IPS tool, for example, need exactly to be informed and to move on how they are going to act when they understand that an incident will take place. So we need to move on specific directions covering this requirement. The fourth cybersecurity requirement is about a role-based access control for data protection. This focuses on the role of each tool that is going to be implemented and integrated into the final CyberSecDome framework. Again, as you can see, this moves on over all main technical tasks. The fifth requirement is about system scalability, which is not a must priority requirement, but it could be applied. And this is about the system scalability and how the implemented framework, which will be mapped on the CyberSecDome platforms, can be auto-scaled in cloud services and can be hardware accelerated. Again, this is based on my notes. This direction, this requirement is can be applied for IDPS tool, as the IDS tool is mapped on a hardware platform for offering high performance advantages. So this requirement can be accomplished based on integrating the IDPS tool into the CyberSecDome framework. The sixth requirement about cybersecurity is high system availability and load balancing over distributed databases. And this focuses on the availability of the systems and how these data backups can be used for reloading the status of the CyberSecDome framework when when an issue exists into the platform. The seventh requirement is about comprehensive logging and real-time monitoring. This requirement is should-based. It's non-functional. And again, this requirement is based on logging incidents that take place during the proper processing of the CyberSecDome framework, and how this can be managed with real-time monitoring for security issues. Next we move on extensibility for future integration. This also is really important, and this direction has been discussed many times in CyberSecDome meetings, because we need to define exactly how the proposed CyberSecDome interface and framework can be extensible and can be used to more different platforms and more different frameworks, and they can be how more different frameworks can be integrated into the CyberSecDome. This is the last about the cybersecurity compliance requirement is interoperability with external systems, as CyberSecDome framework is not the only framework that runs. We need to make some extensions. We need to make some clear statements that what data needs to be exchanged between CyberSecDome and external systems, which can be also AI-based, in order to work and offer high performance advantages when the CyberSecDome is mapped and runs. Last, there are the requirements based on ethics and AI. Here, we concluded to three different specific AI-based requirements. The first one is about accounts, AI models, and accounts. CyberSecDome AI models for CyberSecDome need to be documented and will be used by specific accounts that will be created over the framework. So the important thing here is what type of information do the AI models need, and what type of what information are the different accounts going to be exchanged and used. Here, the priority is high, is a must. It's obviously not functional, and there are two related tasks about data acquisition and preprocessing model and communication and threat intelligence sharing. The second one is about ethics review board for AI. Ethics review board can be established for continuous monitoring for AI applications reviews. And also here we need to define the processes that this board is going to run for as a review. There are two tasks related to this requirement. The first one is 5.1, which is about implementation and alignment with pilots. And the second one is monitoring and assessment of the open call. As you understand, this is more generic, and we need to see how we can integrate the open call results into the CyberSecDome platform. The last one is about the continuous AI performance monitoring. This should be implemented. It's a functional requirement. It focuses again to the same tasks as ethics 01 requirement. And this requirement describes that we need to set up continuous monitoring the integrated AI models based on their performance and based on specific fair metrics. So these 14 different requirements were the results from the outcomes from the questionnaires that you filled in, and these are the directions that CyberSecDome needs to move on in order. Can you hear me?
Yes.
Yes, yes.
Okay, thank you. So, because I hear the noise, and these are the directions that the CyberSecDome needs to move on in order to conclude to a specific output, which will be according to the requirements that we set up in this in deliverable 2.1. So this was our presentation. I don't know if you have any question. I hope I didn't confuse you.
No, no. I see Ana Maria has raised her hand. Yes, please, Ana Maria.
Yes.
Yes. Thank you, Grigori, for the presentation, and Spiros for the previous one. I just want to ask, what about the requirements that we need to define that are mandatory? Especially, I'm talking about the ITML requirements, because I can see that we have also some AI that needs to be defined regarding the which data we are going to exchange on which external systems, etc. So, what's the plan for this? I mean, do we have to when we need to define those, and are we going to submit it somewhere in a deliverable?
I don't know, Spiros.
I can answer that because especially for the tasks that are under, let's say, work package 3, the first deliverable where all these AI tools, let's say, that will be developed,
Yes.
the first deliverable that all these tools will be documented is deliverable 3.1, and ever since the twist between the Airbus and TAS, now we lead the Task 3.3, so we also lead that deliverable. And while Gregory was presenting this, I was also thinking about it, and most probably, if I think we have already covered this in the table of content that we are going to present for the deliverable. I think on Monday, where we have the work package 3 call with Mina. There, most probably will be, let's say, the answer to all of this. So the
Okay.
tool owners, the tool owners will have to, let's say, provide all this information there, and of course we will need to clarify that, document the information, for example, the data minimization mechanisms, if they are present or not, if the tools or specific technologies can support the encryption of data sharing exchange, if we have some such mechanisms. I guess tool owners, tool providers, and technology providers that will elaborate with this deliverable will report this information there. And I think that this table, Greg, could also be used in an action point. For example, if you could provide this table with the questions that you have added in another column next to the priority, so that we can utilize that and get all the information that we need for that deliverable, because most of these are included there.
Okay.
Mhm.
Okay.
Okay. Okay. So yes. So probably we could discuss it further on the work package 3 meeting, right? Monday
Yes,
with Mina.
yes,
Okay.
yes.
She couldn't join today because she's another call, but I will let her know about everything we have discussed here.
I will also try to upload the recording, Santa Maria, on the SharePoint at least as soon as possible. So if Mina, because she was in
Maybe
the
if
call
she
today,
wants. Yes. Okay.
if she wants to, watch the segments that she missed, she can do that.
Mhm.
Because these are very important. I mean, most of the functionalities and the description of interconnections and all of the technological information needed to develop these
Yes.
tools, especially the AI tools, will be reported not deliverable. And we plan to present a draft table of content for that at least on the call. Me and my colleague Vagelis have been working on this, so I guess we will also need to include this table, Greg. So I will borrow this table for that presentation, if you don't mind.
Yes. No,
Yes, it
no
will be
problem. Of course.
helpful. think so.
Mhm.
Okay. Thank you, guys.
And maybe another comment from my side. Thank you, Greg, for the presentation. Really nice. Maybe it makes sense, Piros, for maybe on the Monday call for Work Package 3, that we have to clarify that, of course, here we have for the preliminary analysis, I mean, Task 2.3, we have identified some, let's say, the most straightforward, the relevant tasks for its requirement. But I think also the task leaders, since we can't know precisely what each task will exactly incorporate throughout the development of the project, that the task leader should also, investigate this and check out whether any of these, especially the mass requirements, are applicable to them. So
Yeah.
I don't think we should just, focus on like ITM, LSTS, and OT for requirement 1. I think that everybody should just pay attention to this. Thanks.
Thank you, Kostas.
And,
Very good point.
and also, sorry, Spiro. And also, Costas, we need to define exactly the way that these requirements can be covered. Because are there data minimization? Of course, the issue is not only for the 3 leaders of these tasks, but we need to clarify exactly the way that we need to cover these requirements, either for each tool or for each partner. I don't know, but
Yes, I
yes.
totally agree. I guess that would also require the input from the corresponding partner, and also I guess that at least in certain cases, for instance, data minimization, could be achieved like by design. And correct me if I'm mistaken, Greg, but I think, for instance, the IDS sort of achieves data minimization by design because it only generates signatures and it sends network packet metadata to the incident investigation component, not the actual data.
Yes.
So
yes, exactly.
Yeah, so we should also keep this in mind. But yes, I totally agree.
I'm sure that all partners are aware of, especially technical team members are well aware of these, the answers to these questions. I recall now that when we were trying to relate the requirements with tasks, we tried to do the exercise, but I agree with the Kostas that perhaps now it would be the moment to ask for everybody's help and try to map in more detail the requirements to the tasks. What I know and I can answer for sure is, for example, if there is a deliverable that is going to, let's say, report on specific tools like the one in 3.1, that will report on the AI technologies and tools. I guess all these requirements should be covered, at least the questions raised here. These should be covered in those deliverables. It's especially for the must ones. I think
Yes.
it's
Yes.
evident that we need to cover this. And maybe perhaps I'm not sure about this regarding the second aspect, the cybersecurity
Cybersecurity, yes.
compliance. Yeah, since we are, I think at this moment the Cyber Resilience Act has been voted. Please, Stavros or Georgia, please correct me if I'm wrong. We are at the stage that we expect it to be published as well in the official European journal, or it is at the stage that needs to be to have a final, let's say, approval and confirmation from the Parliament.
I think it's pretty much on the same status.
With the AI Act, okay.
Yeah, they're pretty much. I think I'm not very sure about it, but I think that they're the same status at the moment.
Okay, so this means that we need to, because there is the NIS2, as it's going to be called. I think there is already documented and available to everybody. We need to have a look again at that and make sure that the requirements not only related to these aspects, but all the requirements there will be covered, because I think it will be in effect very soon. I think it is going to affect the progression, the development, and the progression of the project, developing the tools, because it will be in effect within the lifespan of the project, and we need to make sure that we are fully compliant. We took it into consideration during the preliminary analysis, but we need now to double check if we have all those regulations, all the everything that is reported in the NIS2. How it would be called, I think, that way here in this table. If we missed something, that's another comment from my side. Practically, this is a discussion that now needs to be taken into under Work Package 3 and under Work Package 4 for sure, because it will affect the development of the tools, the integration phase.
Sorry, Spiros, for the interruption, but
Yeah.
perhaps we should clarify this because I see now that the NIS 2 directive has already been published and it will be implemented in October of 2024.
Okay, thank you for the update, Stavros. I think, yeah, this affects us a lot. It will be practically be in effect a few months from now. So yeah, we are. I guess we are working under the NIS2 for the development phase. What do you think, Kostas, Greg, or any other who wants to comment? Please, now's the time. This is an open discussion.
My only comment is that that's why I went to this slide, and the Work Package 5 should be integrated into this direction, because there are tasks like open call. I think 5.5 is open call. Yes.
The problem with the open call is that ever since we have been not questioning, we're trying to define exactly what the open call will be, and eventually what the result was that the open call will eventually have, let's say, participants trying to, let's say, provide more use cases for the CyberSecDome. I'm not sure if just the TAP 5.5 can be portable for all these. We could and should. The second one, the E03, ways for optimizing the AI CyberSecDome frameworks. Yes, I think this could be somehow covered, but the AI, the review board for the call, perhaps that will be covered from the team. I'm not sure if we can we can have internal advisors there, unless we include someone, I don't know, from the AEAB, or we have someone at a voluntary basis. But I leave that, unfortunately, analysis is not now on the call. I leave that for clarification because we need to finalize the technical content of the call. This has not been finalized yet. I think we have a dedicated call for this, and perhaps this would be also brought into that attention.
Yes.
Or for the cyber resilience, at least aspects that affect the Work Package 5. Okay, so I don't know if there are any other comments or something else that you would like to discuss based on the presentations that were held today, because we still have 10 minutes left before we officially close the workshop.
Spiros, can I ask something?
Yes,
I'm
of course.
from I try to get to the stream because I'm new to the project. I have a question about the requirements that Gregory has shown. The data minimization management, which OT is with the task 5.1, with the pilot implementation. I just want to clarify that I understand that in Work Package 3, we put the specifications and the specs for the tools. Okay?
Yes, for the AI tools that will be developed.
So this is connected to the tools that we use in the pilots, and OTE must follow these principles that we will discuss in Monday.
Yes, first of all, welcome on board CyberSecDome. Keep in mind that all these specifications and requirements are initially reported in under Work Package 2 in deliverable 2.1 and 2.2. 2.1 includes all the recommendations, the user requirements, and so on and so forth. And deliverable 2.2 initiates a discussion on the architecture and the development of the tools. What Work Package 3 comes to do is actually provide more information and elaborate regarding the AI technologies and tools that will be developed as part of the CyberSecDome framework. For example, the instant investigation, the intrusion detection, all of these technologies. So in deliverable 3.1 that is starting to be under construction, I mean the TOC at least, the table of content, for sure, we will ask from partners that will bring the technologies or the partners that will be responsible for developing these tools to provide answers on such questions. I guess data minimization, either by design, either implemented, it won't be, let's say, it won't affect a lot the interconnection with systems and technologies outside of CyberSecDome. Once the data is being minimized and anonymized, I think this is a problem solved, I guess. Please correct me if I'm wrong, but this needs to be clarified for sure. It will be for the AI tools at least in deliverable 3.1. I guess the same thing will be applied under Work Package 4 for the tools that are being developed there.
Okay. Okay.
Probably this will be a point for discussion on Monday. Under Work Package 3, we'll have the HTML holds the call for Work Package 3, and I guess it is something we will be discussing there for sure.
Okay, Spiros, thank you.
Thank you. Okay, so any other questions or comments? I think not. I don't see any raised hands. Again, let me remind you that we are discussing on having, let's say, another presentation soon. We will see when, probably in Paris, for the Cyber Resilience Act. Probably Stavros and Georgia will do that presentation as well. If you liked what you heard today about the AI Act, let us know. Give us some feedback so we can prepare better for the Cyber Resilience Act. Of course, all the presentations will be uploaded on SharePoint, so you will be able to have a look at the presentations and the slides there. I will send a follow-up email once this is done. The recording will be also uploaded. We might also plan, I don't know, Anna Maria, to use this recording if we want to upload it on YouTube, refine it a bit, but we will need your consent for this. So I guess Stavros will prepare a form that we will send you and ask for your permission to upload this workshop on the social media of CyberSecDome as well, because it is also a dissemination action, and I think Anna Maria, that you could exploit this and add it to the YouTube channel for CyberSecDome. So if you want the material, we will need to ask for permission from the participants today, and we will do that. Let us know if you want it.
Yes, we can do it also, especially for the YouTube channel. And we have a great material regarding the AI act. So I think we could do it if the partners agreed with that.
Perfect. Okay, so we will send the consent form to everybody, guys, that attended today, just for us for permission to use the material on social media and provide it to ITML to upload it for dissemination purposes. If there are any other comments or nothing else to discuss, I would like to officially thank you for joining today to this workshop and conclude this event. I will stop the recording. Thank you all for attending. I hope you enjoyed today's presentations and discussions. We will be in touch. As I said, I will send everybody